So my name is Harum Mukhayer, and since I'm among colleagues who know me, I feel like an introduction would be a bit redundant, but I'd like to share a couple of things about kind of where I come from. So I trace my ancestral descent from a camel herding tribe that settled in kind of the northeastern part of the Sahara, south of the Nubian kingdom, within the Sultanate of Darfur, or Four Sultanate. It's located 200 or 300 miles west of the second or third cataract of the River Nile. And I am intentionally being ambiguous about the country whose territorial sovereignty has defined my citizenship and determined the various visa complications I must endure. So that's kind of where I come from. So a brief overview, also known as Sudan. So a brief overview of my presentation. I'll be talking a little bit about what my PhD or what my research is. It is on aspects of territorial sovereignty and international boundaries and kind of the law, the international law that underpins that. I'll also be talking about why this is a problem and some of my arguments, the experiences that have informed my argument. Then I'll speak a little bit about how I approach these questions within the parameters that my supervisor is willing to kind of permit, and a little bit of some concluding remarks. So what is it that I'm researching? So I specifically look at territorial sovereignty under international law with a focus on land areas and the territorial sea of states. So basically anything you could see on a general political map. So I don't look at airspace or kind of how territorial sovereignty attaches to various natural resources or marine resources and so on. So it's only focused on land and territorial sea. And this is important because a lot of international law on territorial sovereignty is very generous in its grant of territorial rights to states. States under international law have kind of exclusive territorial sovereignty. They have absolute control over their land and territorial sea. And one of the kind of fundamental aspects of international law is the protection of the territorial integrity of states. So that's kind of what I look at. But states aren't the only kind of legal beings that have territorial rights or rights attached to land and territory. In my PhD, I specifically look at like the state rights to territory and people's rights to territory. And I look at that not within kind of the framework of human rights law and people's rights to property or individual rights to property, because these fall within the same kind of state-focused framework of like land rights. So every land right under human rights law would fall subject to the state. And what I'm saying is that international law actually creates two forms of territorial title. It creates title that is vested in states and title that is vested in peoples, whether they're indigenous or tribal people or minority people who existed prior to the formation of states. So kind of that's where I'm looking at it from a more kind of normative standpoint. But the main issue at hand is that while states have this kind of exclusive and confirmed rights to territory, 1/3 of the world's population is landless, out of which 300 million indigenous people are indigenous people without lands, without claims to like their own tribal or indigenous land. And these indigenous people help manage 50% of the world's like global land cover, and only 10% of whom have recognized right to land, so recognized official title to land, which kind of, you can see the contrast between how states are responsible for peoples and lots of peoples are displaced or have no land. And so this is kind of setting up what it is that I look at. So why? So aside from it being kind of fundamentally unjust, that people should remain landless in territory that kind of belongs to them, it is also important in terms of, in terms of subsistence, in terms of poverty, in terms of access to food, access to resources. And the reason this is personally important to me is because before I decided to kind of do a PhD, as Jenny mentioned, I worked with the United Nations in Sudan, in South Sudan and Somalia as a natural resource law specialist. And a big part of what I did was to work with governments in terms of managing their natural resources and implementing international multilateral environmental agreements and conventions. So like the Framework Convention on Climate Change or the UN Convention on Combating Desertification. And in the areas I just mentioned, there are large populations of kind of nomadic people or agro-pastoralists or pastoralists who rely on kind of international migration, so crossing international borders and boundaries. And so that is the context I was working on. And the environment is kind of by default a bit more transboundary than like international borders would like it to be, right? A lot of people kind of need to cross it and rivers cross it. And so the nature of the environment is kind of more fundamentally more kind of is interconnected. And that's kind of what I wanted, that I was curious about. I was curious if there was an obligation on states to protect the rights of people who rely on transboundary resources or rely on crossing international boundaries for kind of fundamental things that are necessary not only to their culture but for subsistence reasons. And I was surprised that no such obligation exists. States have absolute control over their borders and their boundaries, and at any point they want to close the boundary or kind of erect a wall, they can, and they're well within their right. And so that kind of, for me, was interesting to see, do they actually have a right to have a border or a boundary? And a little bit of kind of one of the tangents I went on in my earlier this year was that no such right exists. So what states have is they have territorial rights that essentially end at the boundary, right? And if that boundary is the end of rights, a boundary basically, at least in the kind of philosophical sense, is the absence of a right. This is an argument that my supervisor, as an international lawyer, felt I shouldn't necessarily pursue, but it is kind of, I think it's an interesting way of looking at boundaries as kind of a connection of multiple rights and necessarily not a single body of rights. So that's kind of part of like why I'm curious about boundaries. But in a legal sense, I'm curious about boundaries because of the communities that are transboundary, and a lot of them do have rights within their territory. So for example, if you think about Native American tribes, the 567 federally recognized Native American tribes are considered sovereign within their tribal territory. And so I was curious how that sovereignty translates when they cross an international boundary. So for example, Native American tribes across the US-Canada, US-Mexico border. And there is a case that was in Canada, in British Columbia, where a member of the Colville Indian tribe, which is a federally recognized tribe in the US, they have their territory kind of historically extended into Canada. And as part of one of their rituals, they hunt for like a specific species of animal. And while hunting on the Canadian side of the border, they got into trouble, and the British Columbian kind of authorities were like, you're in violation of the Wildlife Act and you're subject to all these various constraints and you're not allowed to do it. And they were like, well, actually, this is our tribal territory. We have an Aboriginal right to hunt, and you're actually infringing upon our right by saying like we're trespassing. And it was really interesting, like the reasoning the court presented, And they were actually, the court decided in favor of the tribe or the tribal member because they found that they do have a kind of a continuing territorial right attached to hunting. So this is one example of how and why this is like a really important question of not only state rights and their sovereignty, but territorial rights vested in people. And this is just one example. So how much time do I have? Sweet. So how do I approach this? So I approach this by looking at international case law. I look at kind of pre-colonial or colonial case law, as well as post-colonial case law. And it's interesting because there are kind of two main rules and principles of international law that govern territory. The first is that the boundaries that were fixed, or the colonial divisions that were decided during colonization, at the point of independence, they become fixed. They form the boundaries like we see now on political maps, unless they're negotiated and changed through treaties between states. But for all effective purposes, that is the rule. And it's called uti possidendi juris, and that's kind of one of the most fundamental aspects of like territorial sovereignty and the law governing territorial sovereignty. And the other one is kind of complements that. So if there's a dispute between two states as to their boundary, they look at, is there a line, a colonial division? And in the absence of a colonial division, they try and establish who has exercised effective control over the territory. So these are more or less the two general governing principles. And it's very interesting how international courts kind of interpret evidence presented by states supporting their claim to territory. So to take an example, there was a dispute between El Salvador and Honduras over their boundary. And they were both kind of under the Spanish crown. And so the colonial division was never intended as like a really fixed and firm boundary. So the colonial division was like pretty much useless. They looked at, Honduras kind of presented a claim saying that, well, we would like to show that the extent of our sovereignty extends up to this certain point. And what they were using to show the extent to which their sovereignty extends were title deeds. So there were title deeds granted by the Spanish crown to indigenous communities. So that is what Honduras was trying to use to show that this is their claim. And to me, for the International Court of Justice to see this as evidence of a state's territorial right, to me is a little bit kind of like has an element of legal construction. Because if anything, this is evidence to indigenous and tribal communities having a collective territorial claim that was recognized by the Spanish crown, right? And so that to me is kind of like an inconsistency. And so I try and look at why the court decided that and if there were other options. And a lot of the time there are other options, but they kind of choose to follow the colonial path. And so this is one example. There is another example of there's a dispute between Burkina Faso, Mali, and the court tries to find the boundary line. There was no boundary line. And so they relied upon the village marks. So villages as territorial markers. They're trying to see where these villages were, who is administering them, which colonial authority, and on that basis they would decide who has claim or has a stronger claim to effective control over that territory. And it's really interesting because they did a bunch of studies and they tried to look at maps and they're like, well, these villages kind of move because the people were nomadic, and so there's no fixed village to kind of anchor this on. And so they just basically decided to draw a line based on some like maps or just an interpretation of where these villages are or who is controlling them. And as like consistent with my argument is that these people, these communities, these indigenous or tribal groups or even minority groups have a territorial title that courts recognize, that states within their boundaries, like the Native Americans, they recognize they have a territorial sovereignty, not only a right to land, but it has a territorial character. So essentially what I'm trying to do in my PhD is present a legal argument that supports the fact that these indigenous or tribal people, the 300 million of them, or 370 million of them, which is approximately the population of the United States of America. So it's a lot of people, not only have rights to land, but have a territorial claim. So I'm kind of attempting to elevate the kind of rights to land conversation to a territorial level. And this has pretty profound and significant contributions if done in a way that doesn't kind of touch on the politics. So a big part of like my PhD journey has been to look at essentially political arguments presented by states in international courts using law, and seeing how that's not actually law, what they're doing is actually politics, and trying to show like these are the set of legal rules and they apply to indigenous and tribal people in the same way they apply to states. And any kind of changing the rules or interpreting them in a way that presents indigenous and tribal people as like beneath law, beneath states in terms of rights is not consistent, it's not correct, and it's an omission that international law needs to justify. So that's kind of where I'm coming from and where I'm going with my PhD, and that's the arguments I'm attempting to present. I know I started off by rejecting the whole kind of Sudan thing and where I come from, but I would like to end by saying that Sudan actually has more pyramids than Egypt, and this is a picture of the pyramids that we have in Sudan. Thank you.